start. So welcome to today's webinar. My name is Crystel Rynne and I'm the CEO here at HRLocker. I am delighted to have Emma Marmion with me today from Adare to talk about all thing Organizational Working Time Act. Emma, we're excited. Thank you for taking the time.
Of course. Thanks so much, Crystel.
So Emma is HR and employment law specialist with Adare. What we're going to do is Emma's going to have some slides to go through. As always, we have the Q&A section open. So throughout, if anybody just wants to put a question down, and I'll interrupt Emma to ask your question to them. And then obviously at the end, we'll share the slides and the recording of the webinar as well, and all Emma's details. Excuse me, as well, if anybody wants to follow up or anybody has any further questions. But Emma, thank you so much for taking the time, and over to you.
Good morning, everybody. So as Crystel said, my name is Emma Marmion and I am HR and employment law consultant with Adare Trusted People Partners. So firstly, I'd like to thank Crystel and the team very much for having me here today. It's a pleasure to be speaking with you all. So over the course of the next 60 minutes or so, I plan on taking you through the key considerations really and the risks and some case law to close off in the area of working time, which HR professionals and employers alike do need to be aware of. So just a little intro on who Adare are, for those of you who may or may not be aware. We are the leading experts in employment law, industrial relations, and best practice human resource management in Ireland. And we provide a range of services to organisations in terms of firefighting and partnering with organisations in terms of underpinning them for various supports. So just in terms of the specifics of our services, as you can see there from this slide, we partner with organisations across the country on a continuous basis to provide advice, guidance and best practice around all employee-related matters right through to legal representation at the Workplace Relations Commission, or the WRC as it's better known. And we support a wide variety of organisations throughout the country, supporting with compliance and contracts of employment and policies and procedures on all things HR, EOR and IOR, all the things that I'm sure you're all very familiar with. And we also provide a range of HR consulting services around areas such as conflict management, dispute resolution, and carrying out investigations, organizational development and training, and equality and dignity at work training, to name a few. And this will be kind of my area of expertise. And finally, then we have an in-house health and safety expert who provides services in terms of partnering with businesses and also consultancy services through audits, safety statement reviews and developments, and of course, health and safety training. So that's just to give you a bit of a background from where I'm coming from. So in terms of the agenda for today, I will firstly provide you with a breakdown of the Organisation of Working Time Act and the associated pieces of legislation that you should be aware of that a lot of employers and managers alike are not. So it's one thing that I'm going to start off with and get into a bit more detail as we go through. And then I'll go through what the Working Time Act covers, which is working hours, breaks, and so on. And I will then provide an overview of what employers are expected to record in terms of working time and what you need to keep on file. And I know timesheets are a key focus for the session today. So I'll go over what a legally sound timesheet looks like and how, timesheet records really help avoid claims and the dreaded WRC issues. So I'll then, chat through some case law around that, which shows the kind of common mistakes employers make and how we can all best avoid those. So I'll be going through the requirements under the Organisation of Working Time Act in detail through this session. However, at this juncture, it's important to note that this act sets out to effectively protect the health, safety and welfare of employees by regulating their working patterns. And that's kind of a broad term for all the different aspects I'm going to be chatting through today. So in terms of pieces of legislation that I want to make you aware of when looking at and considering the Working Time Act, the following three pieces on the screen there are really important, and I'll give you a quick overview now of them, but we'll get into a bit more detail on them through the course of the presentation. So firstly, the Organisation of Working Time Records, Prescribed Forms and Exemptions Regulations 2001. It's an absolute mouthful, but this piece of legislation requires employers to maintain working time records in respect of all employees. So this is very much a legal requirement. Again, I know this is a key focus for today, so I will get into more detail on this as we move through the presentation. But this piece of legislation effectively requires employers to keep records of what time an employee begins their shift, what time they take their break, what time they're returning from their break, and what time they're finishing their shift. So this piece of legislation very much goes hand in hand with that Working Time Act to ensure that employees are receiving their minimum rest periods and not working over the maximum work week of 48 hours per week, which I will definitely get into more detail on shortly. The second one there is the Miscellaneous Provisions Act, which came in 2018, and you wouldn't believe the amount of breaches of this that still happen today. So this piece of legislation really aims to address issues that arise for workers with unspecified or unsecure hours of work. So really the most important aspect of this piece of legislation is that, or the aspect that is most commonly breached or not reflected on, is that it requires contracts of employment to actually include the weekly and daily hours of work that you as an employer reasonably expect that employee to work each day and week, and emphasis on the reasonably expect. It does not have to be exact. Obviously, this will ebb and flow with busier and quieter times. And finally, then, that EU transparent and predictable conditions regulation. So that came in towards the end of 2022, so it's fairly recent. So this sets out to provide employees with more clarity in relation to their working conditions. So it introduced a variety of new criteria, which I will get into shortly, but the key ones being that the contracts of employment must be issued within their employee's first month of employment with you rather than 2 months. And another key one there was new limitations around probationary periods, where they're capped at 6 months and only extended under limited circumstances. Another one there that I will get into a little bit more shortly is around parallel employment. So the predictable working conditions legislation is saying to us that employees can no longer be prevented from taking up additional work outside of their primary job with yourself, unless it's justified. So if it's obviously in direct competition with their employment with you, that would be a reason to prevent that. But another key criteria with that I'll just highlight now is the increase in details to be included on a 5-day statement. So that is the core details which must be issued to an employee within their first 5 days of working with you. So the details that must be included have been increased. So if any of you are working off templates of a 5-day statement, just make sure that those have been updated since the end of 2022 or beginning of 2023. Okay, so getting into the Organisation of Working Time Act more specifically, and to start off really with the basic. So working time means any time that an employee is at his or her place of work or at his or her employer's disposal and carrying out or performing the activities or duties of his or her work, and work shall be construed accordingly. So features of the Working Time Act which would not be considered working time would be break times and on-call or standby time. But it's important to note with that being on call is not considered working time, since the individual is not actually required to be at a particular place or not be required to be a physical presence at their place of work. But, actioning calls, answering texts, replying to emails, doing on-call reports, or any other tasks pertaining to the work would of course be considered working time. So that's one thing that anyone working in an on-call arena would need to be very aware of. So under the Organisation of Working Time Act, employees are entitled to the following, which I will go through in more detail as we move through, but minimum break periods, minimum daily rest periods, minimum weekly rest periods, maximum weekly working hours, entitlements in respect of Sunday working, specific entitlements for night workers, annual leave entitlements, benefits to be provided in respect of public holidays, and of course, the right to disconnect. So that's just an overview, but I will be getting into some of these in much greater detail shortly. Okay, so what happens if an organisation is actually in breach of the Working Time Act? And this slide is very much in relation to a WRC inspection, which I'm sure some of you have been through the horror of. And they have become increasingly more common since the COVID-19 pandemic, because obviously they weren't entitled to show up to your workplace at that point. But inspectors don't need to provide you with notice of their inspection, while most of them do. Depending on what sector you work in, they can simply just show up at your workplace and begin requesting this documentation. So they will complete their inspection, be it with notice or not, and then the inspector will then provide you as the employer with what's called a contravention notice once they've completed their assessment or audit or inspection, whatever you want to call it, which details what records you have not provided or you failed to document correctly. So this contravention notice will basically direct you as an employer to remedy or fix the issues that they've flagged. So, for example, if timesheet records were not complete and documented, or public holidays were not paid to all staff, they'll typically allow you with 21 days to fix those issues and then return to your workplace and conduct another review. So at that stage, then, if you as the employer or the organization fail to comply with the required remedies under the contravention notice, then a statutory compliance notice will most likely follow, and non-compliance to a compliance notice or to a contravention notice is a criminal offence with fines up to 50,000 or possible imprisonment of up to 3 years. Now, that is, I've only come across one organisation in my time doing this that is where imprisonment was applied. But again, the more commonly issued fines are those on the spot fines there in the third point, which amount to up to €2,000 for each breach. And that would be for each employee. So if, for example, you fail to provide pay slips for all employees or a couple of employees, that could result in an on the spot fine of €2,000 per employee. So a heavy enough one. So moving on now to our record keeping. So the details on the screen there must be retained in respect of each employee. And this is again what the WRC would expect to see or review during their inspection. So they need to see the name and address of the employee concerned or all employees, PPS numbers, a statement of his or her duties, a copy of their contract, the days and total hours worked in each by each employee, annual leave and public holiday entitlements and payment in respect of those leaves, and any additional days pay where this is the benefit provided in respect of public holiday rather than paid leave, a copy of any written notification issued to advise the employee of their working hours and where hours are not fixed. So for example, they need a copy of the roster, and then records or rest periods and breaks provided. So this is where your timekeeping is absolutely essential. So unless these have been advised the employee in writing and there are established complaints procedures in place for an employee to raise the issue where the breach of their entitlement occurs. So these records obviously should be, from your perspective, retained in a clear manner or form. So where an organization has like a clock-in system, that will suffice for the retention of most of these records. So if not, then the form OWT1, which I'm sure some of you are familiar with. The OWT stands for Organisation of Working Time Act. So this is a timesheet, which is approved by the WRC, and many organizations use it. It's a manual form, but any other manner in which you can do that incorporates those details. And I will show you an example timesheet shortly. And then in terms of obviously retention time, these records on the screen, these details need to be retained on the personnel file for 3 years, which is again a requirement under the Organisation of Working Time Act. So again, if you're in breach of that, they can incorporate one of those fines if you don't rectify it. So back now to the Miscellaneous Provisions Act. So I had mentioned that one of the key requirements that employers do not, that if employers don't comply under this provision, and it's around inserting the daily and weekly hours into contracts of employment. However, these 5 on the screen are really the key provisions that arose from the 2018 introduction. So the first one there was stronger written terms of employment. So as I mentioned, you now need to provide your core terms of employment within the first 5 days. And this 2018 legislation has now been increased by the transparent and predictable working conditions legislation. So these details here have been increased, but just to make you aware of what it originally was. They then banned 0-hour contracts, and they were replaced by now what's called casual contracts. And the key difference between 0-hour and casual contracts, while there are no specific hours mentioned in either, an employee has the option to refuse any hours offered to them under casual contracts. So this 0-hour contract were prohibited from 2018, but you are entitled to offer someone a casual contract. But in doing that, the employee can refuse the hours. The third one there, minimum payment provision. So employees called in but not given work must be paid for 3 hours at the national minimum wage or the contracted age. This most commonly applies really for those casual workers. And then the fourth one there, banded hours contract, not particularly common to be honest, but employees working inconsistent hours can request a band of weekly hours reflective of their actual hours worked over a 12-month reference period. So if you have employees that work between 6 and 12 or so on, there is a band that goes from A to H that you can apply to them. But typically the request comes from the employee if they want to be put on one of these banded hour contracts. And finally there, the anti-penalisation protection. So this protects employees from retaliation for asserting their rights under the Act. So if an employee is seen to be asserting their rights to, say, break periods and it's not honoured, and maybe they might be treated unfairly as a result of raising those rights, they can raise a claim of penalisation against the employer or the organisation to the WRC. So that's a lot of detail there. You don't need to know that off by heart, but it's just one good thing to be aware of.
I've actually got 2 quick questions here, Emma.
Yeah.
I think a good time to put in. So the first one is a person still entitled to add in their lunch break time if they're taking half a day before 6 hours of work?
So we will be getting into break periods now very shortly.
Yeah. Okay.
So I will go into that in more detail because it's something that comes up a lot.
And then one more then is brief statement of his or her duties. Does the job spec advertise suffice, or does it have to go into the contract?
No, the job spec will suffice, but the best practice way to deal with it is when you're issuing somebody with their contract, typically try and get that done before they start. But when they've started with you on their, induction, when you're giving them their handbook and any other policies, always give them a copy of their more formal job description outside of their contract, because if you put a job description into a contract, those duties are then terms and conditions of their employment, and you don't then have any flexibility around them. So always issue it outside of their contract and allow them to sign it, and that will always give you flexibility to change it. But the job advertisement does suffice once it's issued to them after they have been given the position. Perfect.
Thank you.
Will I carry on?
Yeah, go first.
Perfect. So then just on the other piece of legislation, just to be aware of, is the transparent and predictable working conditions legislation. Again, I've already kind of spoken on this slightly, but this piece of legislation reduced the time period in which you must issue somebody with their contract of employment. So this used to be 2 months. It's now 1 month. One thing to be aware of here is if you fail to provide employees with their 5-day statement, they can take you to the WRC for failure of that, and they can win 4 weeks pay. And if you then fail to provide their contract within 1 month and they bring you to the WRC for that, they can win another 4 weeks pay. So just to be aware of that, it used to be 2 months, but now that there's a 5-day statement in the 5 days and the contract in 1 month, the best recommendation I can give there is just get the contract to them within their first 5 days, or ideally before they start with you. Then the maximum duration of probationary periods in the private sector is limited to 6 months. Now, there is exceptions around this. If somebody is sick for a period of time, you can absolutely extend it, but it does stipulate in the legislation that if it's in the best interest of the employee, i.e. if they are going to be terminated as an alternative to you extending their probation, you can extend in that circumstances, but you must be able to document poor performance or such like. And then this also largely prohibits employees from taking on more than one job. So again, you can't stop an employee from taking on another job unless it's in contradiction or in direct competition with your own. And then there's an obligation to provide more commitment to workers regarding weekly hours. So there needs to be more clarity around that. And finally, employees may request more predictable and secure working conditions. And that really comes around, the main thing was really around the training. So mandatory training that employee might need to do or be part of as part of their role, that should also go into their contract. And that should be things like, safe pass or manual handling, anything like that, that is mandatory for their role should now be put into their contract. So I'm now going to move on to minimum break entitlement. So I know there was a question there, so it's
Entire
good timing.
section.
Exactly, exactly. So minimum break periods, these do cause a lot of confusion, but the legislation thankfully is quite black and white on this, unlike most things. So an employee working less than 4.5 hours in a day is not entitled to a break unless otherwise agreed as a term of their contract of employment, which is incredibly uncommon, but not impossible. So, for example, if you're to work 9 a.m. to 1 p.m., which is 4 hours working time, you do not get a break. But then if you do work 4.5 hours or more, but less than 6 hours, so between 4.5 hours and 6 hours, you are then entitled to a minimum unpaid break period of 15 minutes during that working day. So somebody then working 9 to 2 p.m. is entitled to a 15-minute break, which would be then 4 hours and 45 minutes of working time. And then if you are to work 6 hours or greater, you must be provided with a 30-minute unpaid break during that working day. So it is important to note there that when an employee is entitled to the 30-minute break, the employees does not have to be provided with that previous 15-minute break earned after 4.5 hours. So if you were to work, say 9 a.m. to 4 p.m., which would be quite common, you can be given one 30-minute break, or they could be provided with, say, 2 15-minute break, whatever works for your organization, but you don't have to do the initial 15 and then the subsequent 30. So just, I suppose, to recap there, it's quite wordy. So if you work less than 4.5 hours, no break at all. If you work 4.5 hours or more, but less than 6 hours, you're entitled to a 15-minute unpaid break. And if you're working 6 hours or greater, the employee must be provided with a 15-minute break, which can be broken into if you're working 6 hours or greater, it's a 30-minute break, but it can be broken into 2 15 minutes if you so wish. And in general, really, most employers with staff working greater than 6 hours or more allow their staff a 1-hour lunch break. So most typically it's unpaid. However, some employers do opt to pay this. Regardless of that, that fact will be or should be stipulated in their contract of employment. So always make it clear in the contract if breaks are unpaid or paid.
And Emma, just on this, because I think this is very, very black and white in terms of when you're working. But
Yeah.
if, for example, you pay breaks when the person is working, when they take annual leave, can you take that hour out, or what's
No,
the
you can't. You can't, because that's then a term and condition of their contract.
perfect?
Yeah. Just before we move on then, sorry, I'll go back quickly, apologies. Just so we're 100% clear then. So I'd just like to highlight that minimum breaks must be taken during the working day. So breaks afforded, at the end of the working day are not regarded as fulfilling the requirements of the legislation. So allowing an employee to work through, say, their half-hour break in order to finish their working day a half hour earlier is not appropriate, and that would be a breach of the legislation. So that's one thing that I do get queried quite often. So just to be aware of that, if an employee asks you to do it, if they want to finish up early or whatever, no, they're not allowed to do that. Unfortunately, we would all love to be able to do that.
So 3 quick questions before you move on.
Yeah.
So there's 2 around the contract, but 1 around the break. So we'll just do the break one first. Is an employee's regular daily working hours are 7.5 hours per day, plus a 1-hour lunch break. So I suppose 8.5 hours.
Yeah.
Do employees need to record their lunch break on the timesheet, or is it acceptable to enter only the 7.5 hours worked, assuming the 1-hour break was taken?
If it's paid, you're okay to include it in the working time. But strictly speaking, it should be that break is in accordance with the Organisation of Working Time Act. So the WRC could be a little bit lenient on that, given that it was paid. But the break should be recorded. Start time. If you use a clock in system, for example, what time did you start your break? Clock that in, and what time did you come back?
Yeah, I think
I
this
would.
is somewhat similar again. If the employment contract specifies that the employee receives a 1 hour unpaid break, should the employer follow the contract or the law? I mean,
The
always the law.
contract.
But the
Yeah,
contract,
contract.
okay.
Yeah, absolutely.
Mm.
So if you're giving, like, to be honest, 1 hour
Oh,
lunch break is
traditional.
the most common. Yeah. So you're satisfying the legislation anyway. You're giving them the 45 minutes. So clock it all in. Absolutely. Once you're in compliance with it and once you track it, you're absolutely fine.
Super. So these ones are around the contract. So regarding having a current contract of employment, I think this might actually be more common than than we want to admit. Is regarding having a current contract of employment, if the contract of employment was signed on physical paper, but this has gone missing due
Mm.
to how can I buy this?
It's a nightmare. It's an absolute nightmare. And everyone is in the same boat on this. But unfortunately, it can get very tricky if issues arise. So if the title changes, if the hours change, if anything like that changes, you're kind of in trouble a little bit if your employee is querying what their salary is, what their hours of work are, what their lunch break is. So if you have misplaced the contract, I would absolutely issue another one. Sit down and have a consultation or a negotiation with the employee. Look at if you have records of what their obviously their pay slips, you'd have that. If you have records of their breaks, of what their typical lunch break looks like, and their start and finish times per your clock-in system or whatever it is, draw up the contract based on that. And you always have the window to say, if typically if a contract like that has been misplaced, it's a paper contract, it's probably some years old and the legislation in it is out of date anyway. So it's always good to implement a new updated contract that's compliant with the new legislation. So use that as a reason to do it, but you do need to get those terms signed by the employee, ideally on record, because once issues come up and there's grievances around what my working time is, what my breaks are, you need to have that. It is something that you can fall back on. So if that is the case, try and get a new one in place.
And I think communication them at that stage with the employee to say, look, we're just updating things,
Absolutely.
not
Yeah.
taking anything away from you.
No change to your terms. We're just being compliant with the current legislation.
And then there was one, could you please come back to the comment about the job description not to be included in the contract to allow for flexibility?
Hmm.
What should be included then, and what would be required to change the job description if appendix to the job description compared to be was concluded in the original contract?
So if the original contract, look, I think it depends on the employee themselves. Okay. So strictly speaking, if you put a job description in your contract and you list the duties, any changes that you make to a contract, be it hours of work, your salary, your title, and then if a job description is in that contract, an employee and an employer have to agree to those changes. So if you want to make changes or expand on the job description and it's in your contract, then the employee has to agree to it because it's a term and condition of their employment at that point. But again, this depends on how lenient you can be with your employee and what kind of person they are. There should always be something in the job description that will say that these duties will expand as and when needed with, alongside business requirements and so on. But I would always be issuing a job description, be it through your advertisement or otherwise, in a document not within your contract, but with, say, your handbook, just a separate document that they sign to say, these are my current roles and responsibilities. The reason I say that they should sign it is because if they ever refuse to do it down the line, that you have proof that they have agreed to it. And then because it's similar to a handbook. The reason why, we put policies in a handbook is because these are ever evolving and we don't need employees' agreement to change those policies that are in a handbook, but we do in a contract. So similar with a job description, we need to have that separate to the contract so we can change them as and when business needs, change and roles change and, AI and everything is changing everything, so much. So
Yeah.
always keep that aside. But if you have it in a contract, you have to have a consultation with them and sit down and explain the needs for the changes. What are the business requirements that has led to these changes being required. But again, you will need to have them agree to it.
And I think that's a really good point. We could probably do another entire webinar on
Yes.
this. Even in the job description, I've seen things like even like you report to Emma.
Yeah.
So, you should be putting a line in there, right, to say that this may change or
Absolutely.
the,
Yeah,
the
absolutely. Like put the title of the person in rather than the name. That's something that comes up a lot. Yeah, put the title in. But if you put the name and the title in, you're okay. The name, the person will, often does move on, but always put the title in. So, oh yeah, we could do
generic.
a whole hour on this.
Okay, and then two quick questions, and then we're going to move on.
Yeah.
Our timesheets state we work 9 to 4 with a 30-minute break, but we don't show the time of the break. So
Mm.
it's like a flat timesheet. Should we have a recording system for the actual break taken, or is it enough that it's just written that we've taken a 30-minute break?
It's enough that you've taken it. I mean, once you can show, if the WRC inspect that you could show that the break was taken, then you're absolutely fine. There doesn't need to be, look, I think with the systems that we have these days, the clock in and clock out, it's much more clear. But once you have evidence to show the WRC in an inspection that the breaks were taken, then you're compliant.
Okay. And I think this is a little bit the same as, can you just record the start and end time and then auto take out the break, or do you have to record the actual break time? So you just still need to record the break was
Yeah,
taken if it's not.
exactly. Yeah.
Right. Yeah. And this is probably a fishy question is, do hours worked for a family member or a director have to be recorded?
No, they do not. That's a separate requirement. Yeah. Family organizations are different. So
Yes.
this is all talking private sector mostly.
Yes. Another one we can do on perfect. Okay. So there is, okay, can a title of a role be changed to imply that the position is seen as senior while another person with experience is in the role?
I'm not sure exactly what they're referring to there, but look, title changes, it depends on what the structure of your organization is. Title changes have to be agreed by both employee and employer. But the responsibilities should really in terms of gender pay gap, all this we need to have less ambiguity around why somebody might be paid less than somebody else. So duties with the same titles should be captured correctly and accurately and consistently. So I wouldn't be giving somebody a title that makes them appear to be more senior when they're not. They've different duties to maybe somebody else with that title, just because of all this new transparency legislation.
Yeah.
Yeah, it's I would keep it simple, because look, if that was flagged up in a report, then you'd need to justify why that person is given that title and not maybe the salary and the duties, and you might find yourself in a bit of hot water.
You want to be clear. Okay.
Yeah. Okay, brilliant. So going to move on now to minimum daily and weekly rest periods. So not only are employees entitled to their minimum break periods, they're also entitled to minimum daily and weekly rest periods under this Organisation of Working Time Act. So again, this is quite wordy, so don't over confuse yourself with this, but just to give you an overview. So all employees, except those excluded from the legislation, which are, family members or Gardaí, people working for themselves, they're entitled to a minimum daily rest period as well. And this entitlement is outlined in section 11 of the Act, if anyone is bothered to look it up. And it stipulates that an employee is entitled to a rest period of not less than 11 consecutive hours in each period of 24 hours. So that's your daily rest period. So employees are effectively entitled to an 11-hour consecutive rest period from when they go home on that day of work to when they commence work the following day. And then in addition to that, employees are also entitled to a weekly rest period of, now this can get a bit complicated, but a weekly rest period of at least one period of 24 consecutive hours rest in any 7-day period. And it's section 13 in the Act, which outlines that entitlement. Comes up a lot in WRC cases, because this is one thing that does get flagged quite a lot. But by legislation, this should then also be preceded by a daily rest period of 11 hours. So effectively each week, you need to be allowing one uninterrupted 35-hour rest period per week. And this does sound awfully complicated, but it is effectively the weekends for the majority of workers. And where it's not possible to provide one uninterrupted 35-hour rest period over a 7-day period, then the employee may be afforded the equivalent of 48 hours rest in a 14-day period. So this will again need to be preceded by a daily rest period. So overall permitting 59 hours consecutive rest. That's over complicating things, but unless stated in the employee's contract of employment, it's assumed that the weekly rest period will be provided on a Sunday. So any therefore, where like an employee is required to be available for work on a Sunday, it's necessary to include that requirement in the contract. And again, I'll talk about that a little bit more shortly.
There's going to be a test on this at the end, Emma, isn't there?
How?
There's going to be a test on this at the
Yes,
end, isn't there?
there is. Yeah. So the just important exemptions really to be aware of in respect of those entitlements relate to shift workers, if anybody has any employees in that sphere. And if they can't avail of a rest period due to a shift change, or anybody, employed in activities consisting of periods of work spread out over the day, for example, like a chef working a split shift over a morning and an evening. So to recap again before we move on, again, it's quite wordy. So an employee is entitled to a 11-hour consecutive rest per 24-hour period. So you come home from work, you're entitled to 11 hours rest before you go back to work. And an employee is also entitled to at least one period of 24 hours consecutive rest in any 7-day period. And this should be preceded by a daily rest period of 11 hours. So allowing one interrupted 35-hour rest period per week. And this is most typically captured by your weekend break, which encapsulates more than that, but that is the minimum rest period. And then where that's not possible, to provide one interrupted 35-hour rest period over this 7-day period, then the employee may be entitled to the equivalent of 48 hours rest in a 14-day period. So I hope I haven't completely confused everyone, but I'm going to...
One question, Emma, which I think is really important, is how does this affect if the person's got another job? So what should you do if you are the main employer Monday to Friday, but you
Yes.
know that the employee has a second job and is working both on Saturday and Sunday? What's your responsibility?
Yeah, I actually have a separate slide on this coming up,
Okay.
but I'll just, if you want me just to chat through it now, if you are the primary employer and you offer to your staff, 35 hours per week, you have an obligation to, I always say, always ask your staff, have evidence that you've asked your staff if they're working a second job. You have an obligation to make sure that all employees are not working over the 48-hour maximum work week when averaged over 4 months. But if once you've shown that you've asked, if the employee tells you, you then have an obligation to make sure that you're clear on how many hours they're working on their alternate role, making sure effectively, once you make sure that that doesn't go over the 48 hours per week when averaged over 4 months, you're fine. But they do have to comply with these regulations. So if you've any assumption or you're concerned that staff are working 2 jobs, just make sure that you ask. Have that in writing, because if it comes to it and the employee raises a WRC complaint or anything regarding that, you have evidence that it was asked of them. Whether they told you or not is a different story, but if you've evidence that you've asked, then you're in the clear. But you do have to comply with these break periods. So it can be difficult, if someone's working an office job and maybe a bar or restaurant job, they can't go over that 48-hour average period.
And there's just one question here, so when you refer to private sector, I take it that includes voluntary and community sector as well.
Yes. Yes. Yeah.
Okay.
All right. So I'll move on now to Sunday working and premium payments. So I'm sure we're all quite familiar with this, but there is funny stipulations around this, and it's incredibly unclear actually. So it's a difficult one for organizations to manage. But section, excuse me, 14 of the Working Time Act provides for compensation for employees who are required to work on a Sunday where this has not otherwise been taken account of in deciding pay. So that's an important point. So an employee who is required to work on a Sunday must be compensated in one of the following manners. So a payment of a reasonable allowance for the day, and or payment of an increased rate of pay for the Sunday, and or granting paid leave in order to compensate for the requirement to work on a Sunday. So the legislation does not actually stipulate how much the increase should be, which is very tricky, but it's very much silent in that regard. But what I have seen through WRC inspections is that the WRC will look for a minimum of a 25% increase on minimum wage for each hour they've worked on a Sunday. So if you've any staff working or being paid minimum wage, make sure they're getting a 25% increase on that minimum wage per hour that they work to make sure you are compliant with this. But on the other side of it, and as an employer, you can decide to say in the contract that you've incorporated the Sunday benefit premium into their ordinary annual salary. So if they're on, 45K, for example, annually, this would take into account that 25% increase on each hour worked. So just do the maths when you're if you are want to state that this is included in their annual salary, make sure that they're at least getting 25% on each hour that they work on a Sunday. So again, this also has to be included in the contract of employment. Ideally, I always say include the Sunday premium amount or the percentage increase, for example, 25%, or that it's been taken account of within their annual salary. So it's a requirement that you state that it's either being taken account of or that they are getting an increased rate. But I always say, to be safe, try and include what the premium amount is, or what the percent increase is. So that is a really important area, and it is something that a lot of organizations fall down on actually in WRC inspections. I'll just move on now to the other end of the scale, which is the maximum weekly working hours. So this is section 15 of the Organizational Working Time Act. So the legislation sets out to restrict effectively the number of hours, as I've said here, with the 48-hour max. So we are restricted in terms of the number of hours that we can work in any 7-day period. So the maximum working week is an average of 48 hours per 7-day period, averaged over a reference period of 4 months for the majority of employees, and over 6 months for employees working in, you can see here in the second point, the security industry, hospitals, prison, gas, electricity, airports, docks, agriculture, and employees in businesses which have peak periods at certain times of the year, such as tourism. So in that instance, you can average them over 6 months, and then you can average them over 12 months where there has been an agreement between the employer and the employee to this effect. And then that agreement between employer and employee must be approved by the Labour Court. That must be a legally sound and agreed period. And then the days or months comprising a reference period shall be consecutive days or months. So, when I say over 4 months or over 6 months, they must be consecutive. You can't, unfortunately, pick and choose the months that you're averaging those over. So now just back to speak on the double employment. So I've touched on this already, but just to make it hopefully clearer for everybody. So where an employee is working 2 jobs, they must firstly make you aware. So ideally, the employee should come to you. That is, their obligation. So employers should be. What I would do is I would encourage you to ask your employees to declare this, because that just is a bit of peace of mind. And if you have it in writing, you have it there. You've asked the employee to declare this. If they haven't, that's their own prerogative. But you should be, for your protection, have evidence that you have asked. And then obviously the reason being is that the maximum weekly working hours of 48 hours per week also apply in situations of double employment. So employees working 2 jobs cannot be working greater than 48 hours when averaged over the 4-month period or 6 months between both jobs. So just in that example given there, an employee who's employed to work in an office for 39 hours a week and also works a further 15 hours per week in a pub will breach the act. So either or both employers, so the office job employer and the pub employer, could be found guilty of an offence under the Act in permitting the employee to be employed in excess of maximum working week. So if the employee has declared to you that they are working a second job, you must make sure that you have an account of how many hours they're working, and that this is not over the maximum 48 hours per week averaged over the 4 months. So again, it's really important just to have evidence of you asking. And then if someone makes it clear, you can ask them for the details, how many hours they're working, what their roster is, and so on. So that is a complicated one, but just one to keep on top of. Just always ask your staff if you're in doubt.
We might
So
do
just
the 3
go ahead.
questions here is, if an employee regularly works more hours than stated in their contract, should you just adjust their contract? For instance,
Yes.
employees contract 37, regular 42. Okay.
Yeah, I would absolutely. Yeah, if the average, I mean, when you're looking at their weekly and daily hours in their contract, I would look at the previous 13 weeks and see if over the 13 weeks that the average has gone up. Then yes, I would increase the contract once the employee is in agreement with that.
Okay. Do you have to pay an increased rate of pay for general overtime hours?
No, you don't. No, again, that's something in that should be stipulated in the contract. Now, obviously, if you're an hourly worker, you get paid for every hour that you work. But if you are on a contract that is 39 hours per week, You don't have to pay overtime. Again, that's a term that should be included in a contract of employment. Are you paid overtime? And if so, at what rate? So if it can be the normal rate, time and a half, time and a quarter, whatever it might be, but you've no obligation to do it unless they are an hourly paid employee.
Okay. So linked to that, which I think I know your answer to this, is how many hours extra can you work then if you're already working 39 hours in your permanent employment?
Yeah, so up to that 48 hour. I mean, look, you can do over the 48 hours once it's averaged, once it's below an average of 48 when averaged over a 4 month or a 6 month period, depending on what sector you're in. So yes, you can, but once your average is below 48 or at 48 when averaged over the
So
4 or 6 months.
question here is they've reminded their staff, average over 4 months, to don't go over the 48 hours. If
Mm.
they lie or mislead us, are we covered that we kept reminding them?
Exactly. Yes. Yeah. I mean, look, if they are lying or misleading you, you've no way of checking what their other employment really is if they're lying. So once you have evidence of checking and the employee is giving you the details, that's all you can rely on.
And then flip it on the head in regards to overtime. If someone is paying less and working less than their 40 hours a week, can you reduce their salary? So again, I suppose it's in their job description, right?
In their job description or in their contract. Yeah, again, you would need their agreement to reduce their salary because it's a term and condition of their employment. Be a very difficult thing to get over the line with an employee, but you need to have pretty strong justification. But if their contract says they should be working X number of hours, they should be delivering those hours. So that's what I would be pushing, and you can go down a disciplinary route or anything like that if needs be.
Okay, I'll put myself back on mute, Emma. Go for it.
Brilliant. So, just very briefly, I suppose, on night workers before I move on to timesheets and record keeping, and that's where I will be closing off. So, persons working at night are actually protected under the legislation as well, and they have different and additional rights over normal workers or daytime workers. So, a night worker is defined as an employee who normally works at least 3 hours of their working time between midnight and 7 a.m. the following morning. So in that instance, night work must equate to 50% of their annual working time. So with regard then to their maximum working week, night workers cannot be required to work in excess of 48 hours in a 7-day period, averaged over a reference period of 2 months. So again, another reference period there. So lower for night workers because obviously this is more strenuous work. And when the night worker is involved in work which may have special hazards or heavy physical or mental strain, then there's an absolute limit on working hours. And in that case, employees may only work 8 hours in a 24-hour period during which they perform night work. So there's no way to average that over a certain period. So I just want to touch on that very briefly. But now, before we move on to timesheets, this is just a summary of those key stipulations under the Act. And I can absolutely share a copy of these slides with you at the end of the session. So you'll have a copy of these. But just to recap, we've looked at the maximum working hours, rest breaks during the day, daily rest, weekly rest, night work. Annual leave we haven't covered, but it's quite straightforward as per the contracts. Public holidays, obviously just 10 per year. Sunday work, working time, and the right to disconnect is a policy we could do a completely different webinar on, but it is one section just to be aware of. So now I will move on to the final section of the session today, which is timesheets and record keeping. And I know this was something that everyone was really keen to look at because it's ever evolving. Well, it's becoming more and more complicated, I suppose, because of all the systems that we have available now to record time. But the ways that we can record time, manual timesheets, as I will show you an example. So that will be the OTW form. You can get that online. If you need to use written manual timesheets, that's the best one to use. It has all the details WRC will look for. The best one to use will be clock-in systems, depending on the nature of the organization that you're in the sector. They're brilliant, and Microsoft Teams actually has a free feature that you can have a clock in and out system on. So if you don't want to spend the money on an elaborate system, that is definitely one that is useful, and it records the breaks and your clock in and out. That's an excellent and cost efficient one that I would definitely recommend. You can use digital time tracking or software and apps. So this is something that a lot of home care providers and that kind of thing would use when they're on the go. Can be difficult to make sure that they are accurate at times, but that's something that a lot of organizations with employees that move around a lot will use. and then the built-in time tools in HR and payroll systems, which I think a lot of you are using at the moment, just given the questions I received today. But I would definitely recommend the Microsoft Teams clock in and out system. If you don't have anything in place, it's free and it's readily available. It's just one thing that few clients of mine that I've had WRC inspections that have been a nightmare, they've been able to do them on a platform like that and retrospectively do it as well. So just one thing to keep in mind. Okay, so why do we need to record working time and keep timesheets? This is a question that we all want to know, because it is a burden, to be honest, on a lot of organizations. So the first one there, legal compliance, obviously. Timesheets, they effectively serve as evidence that employees aren't working above those maximum weekly working hours, which is that 48-hour period averaged over whatever the 4, 6, or 2 monthly period, and that they are making sure that your employees are receiving the appropriate rest breaks and daily and weekly rest periods, therefore ensuring proof of compliance with the legislation. So that's the most important thing: proof of the breaks, proof of your weekly rest periods, daily rest periods. So they also protect you as an employer. So they help defend you against disputes or claims regarding maybe break or rest periods that your employee may claim against you, that you're not offering those lawfully. Similarly, another thing that employees complain about is maybe that overtime isn't being paid as per their contract. So this would all be something that these would take track of. So they effectively ensure transparency, and it again reduces the risk of litigation. And they also protect employees, so they ensure workers are treated fairly and they're not overworked. And that then in turn encourages kind of a healthy work-life balance and enforcing rest periods. And accurate timesheets, they also help with, workforce management by, tracking productivity and resource allocation and identifying trends like excessive overtime or understaffing, which is a really useful tool, actually, if you ever do need to do a strategic overview like that. And of course, they also ensure payroll accuracy. So really, the most important aspect of timesheets is to ensure that the organisation is not in breach of the Working Time Act and therefore not exposed to any of the claims we discussed earlier in the section, and those fines that we can also be exposed to. So just to recap and highlight again, the Working Time Act, the records prescribed form and exemptions regulations from 2001, they require employers to maintain records showing daily and weekly hours worked, rest breaks taken, weekly rest periods, and failure to keep accurate records can lead to penalties, including fines or action against, from the WRC. So it's the, we're looking at the Organisation of Working Time Act, but there are those other 3 pieces of legislation which I've talked through today that are so important in making sure that you are compliant. So this is just a sample timesheet. This is similar to the OWT1 form, and again, these slides will be available to you. So if it's just something that you can use, you can print that off, no problem. And finally, then I'm going to chat through some case law. These are just more simple cases, but it does show some of the penalties that we can be subject to. So the first case there is around Sunday allowance. So the adjudicator in this case found that in the period from September 10th, 2019 and until March 13th, 2020, the complainant, which is the employee, was paid an allowance of only 5 cents per hour for hours worked on Sunday. So the respondent, which is the organisation, they failed to comply with that Section 14 of the Organisation of Working Time Act that we've spoken about. And it was also found that the respondent, again, the organisation, breached Section 15 of the Working Time Act by putting the complainant under a lot of pressure to work excessively long hours. So the adjudicator then in the WRC found that, contrary to the legislation, that the respondent was penalised. The respondent penalised the complainant when she was intimidated into continuing to work excessively long hours. So that's where that piece of legislation we were discussing earlier, so they're entitled to enforce their rights, which this individual did. And she was then claimed that she was penalised as a result of doing that, and she was successful in this. And then in relation to the failure to pay a reasonable Sunday allowance, the respondent or the organisation was directed to pay the employee or complainant compensation of €2,000. And then in relation to the failure to prevent the complainant from working in excess of 48 hours a week, the organisation was directed to pay the complainant compensation of €10,000. So the complaint of penalisation was also well founded here, and the respondent was directed to pay the employee €3,000. So total compensation there was 15,000. So significant enough. So that's a long one. These ones I'll fly through. The second case there is really a reminder to employers that any employee is required that any employee who is required to work on a Sunday must be compensated for doing so. So in this case, the employer had stated that they'd pay the employee double time for Sundays since April 2022. The employee had actually not been compensated for working on Sundays from the commencement of his employment, which was 2007, until 2022. So as I previously mentioned, there's no requirement to expressly set out the calculation for a Sunday premium in an employee's contract. Like, it must just be noted clearly and unambiguously that compensation is paid, and this clause was not included in this employee's original contract, nor had the contract actually been updated with that clause. So my advice here is to always ensure a 25% premium is paid, and ideally include that in the contract if you can. And case 3 there, so this highlights the importance of having effective time and attendance systems to ensure that employees' actual working hours are recorded. So this is of equal importance for employees who work mobile jobs, as I'd kind of chatted through there, and they may work across different locations, and that's commonly home care providers, for example. So this case showed that employers should not rely solely on tachograph evidence, so the driving of working time, if the employee engages in work activities other than driving on the road during his or her working hours. And finally, this one, case 4, is always one that sticks out in my mind, just given the nature of it. So Santa's Grotto photographer left stressed and undernourished after being unable to take breaks in the final run up to Christmas, and the complainant did not get any breaks during the last 3 days of his employment and was awarded €200.
Yeah.
Interesting one.
That's a cure for Santa.
Exactly.
Just two quick questions here, maybe just to follow up.
Yeah.
So we use HRLockers, clock in and out system, but we don't get people to actually record their breaks. Should we start getting people to clock in and out for their breaks?
Yes, I would. Absolutely. Yeah.
And again, if anybody's using HRLocker, they can do it on their phones or on the laptop, whichever is easier for people. And then I know the answer to this is it illegal to put 9 months probation in a contract?
It is. It is. Now, you can say that it can be extended up to 9, but it's only in exceptional circumstances. So you have to, really, the legislation says if they've been maybe absent for 2 to 3 months, that will be a reason you can extend them. But if you are going to extend them for performance reasons, it can only be in the best interest of the employee. You need to have very strong evidence that that is required. So by means of probation meetings, notes of meetings taken where they're underperforming. So you need to have really good evidence that the employee is not able to pass probation at that time. But it is illegal to say that the probation period is 9 months, unfortunately, but
Yeah,
it
and I
can be
think
extended.
that's a relevant thing to talk about in terms of the contract. I think it's good, that you're referencing the legislation rather than actually putting kind of things outside of it in there, because even
Absolutely.
if it changes, the contract is still up to date, right?
Definitely. Exactly. So once a piece of legislation is noted in there, that really does cover you.
Yeah. And then I think I'm just going to actually use this as an example of something that somebody can contact you directly about. So if a contract for employment is for a set of skills and that role is no longer a full-time role, is it better to put them on short hours as no longer needed, or move to make the role redundant as there's no other open roles? I think I'm going to get that person, Emma, to contact you to
Absolutely. Yeah. No
discuss
problem.
that, because it's kind of
More complicated. Yeah.
whether there's a redundancy, not redundancy. It's a
Yes.
difficult one. Um,
Brilliant. Well, look,
but
that brings my
thank
presentation to
you.
an end
Yeah.
anyway. So thank you all for your attendance. I hope you took something from it. And thank you so much, Crystal and Glenn, for having me. It's been a
And
pleasure.
thank you, Emma, so much. And so, as I said, we'll be sharing all the slides and the the recording with everybody as well. If anybody has any questions, please contact Emma or myself directly. And again, if anybody's using any of the timesheets within HRLocker and just wants to kind of go through how to clock your breaks or kind of how to look at making sure people are actually using them properly, we contact somebody in support and we can talk to you then. So thank you ever so much, Emma, and hopefully we will talk to you soon.
Thank you so much.
Bye-bye.
Bye-bye.